So again, this is a relatively new part of the Australian consumer law. And it basically applies, so it provides this unfair contract regime, which immediately you think, oh, that's good. So if we have unfair contracts, then somebody's going to do something about it. But it actually has a relatively limited scope. The regime applies to standard form contracts. So essentially contracts that are the kind of take it or leave it types of contracts. Things like your utility contract, your telephone contract, dare I say it, your contract to do your JD with the university, the terms of your health loan, contracts where there is no real negotiation. The offer comes in a standard form and you get to take it or walk away. So it's a classic offer and acceptance. It might be that it's framed in such a way, standard forms are often phrased in a way that you make an offer on the terms that the other party only signs or accepts afterwards. But it's that classic, it's not really a consensus at even approach. So it basically applies to both consumer contracts, and since November 2016, so since the end of last year, it's also applied to small business contracts as well. So the regime basically says that standard form contracts can't contain terms that cause significant imbalance in consumer rights, as in, so the rights of the business can't be unfairly greater than those of the consumer, that are not necessary to protect the business interests or that cause detriment to the consumer. A standard form contract is usually one that's offered on a take it or leave it basis. We talked about that a second ago. So, and we end up, the standard proof for that is there's a presumption that it's a standard form contract. The party who needs to rebut that presumption and say that the regime doesn't apply is the organisation issuing the contract. They're the person best placed to rebut that presumption. Some doesn't mean that every kind of term that's in a standard form contract is subject to the regime. So terms that define the main subject matter, that set the upfront price, or that are required or expressly permitted by some provision of the law. So for example, standard form contracts that include cooling off periods for door-to-door sales, type of term that is required by the law to be included in that type of contract, they're excluded from the regime. Only a court can decide where a particular term of a standard form contract, a consumer contract, is unfair or not unfair. So a court needs to make a determination that a term is unfair. Applies to business, anything, the test for business is quite similar, if not identical, to the test for consumer guarantees, which we spoke about the other day. So if you employ less than 20 people, if the price of the contract is $30,000 for a one-off, or if the contract's going to go for more than a year, the value is up to $1 million. And if the contract, it applies for contracts entered into or varied, that includes a renewal after that time. So, what does this all mean? If within the circumstances the law describes, and we'll get onto those in a minute, a term is declared to be unfair, then the term will be void. It can't apply. If the term can be severed, then the remainder of the contract will continue to apply. The court needs to consider a range of different factors in working out whether it's unfair or not, so it's relatively prescriptive. And a term will be unfair if it meets these three tests that relate to the imbalance in the party's right, the protection of the legitimate interests, and the detriment to the consumer. Section 25 provides some examples of terms that are unfair, and there are a range of remedies that are available as well. Once a court has declared that a term is unfair, a person who's a party to the contract where that term is declared unfair, we've got this void provision, etc. But future times that it is used, So if say, we're talking about, I use the university as an example before, heaven forbid that they have unfair terms in their contracts, but let's say they do. If a court made a declaration that a particular term was unfair, like that you had to do exams, for example, then once that declaration had been made once, then that term would be considered unfair if it was used again. Okay, without remedy. So, what is the effect of unfairness in a consumer or a small business contract? I had a bit of colours, don't I? Firstly, we need to work out whether it's a standard form contract. So I'll talk about that. That's section 27. We'll talk about it in a minute. We need to know that it's a consumer contract. Should have changed that bubble to say, or a small business contract. That's pretty easy to just follow the section, work out does it fit within that regime or not. It also at that point we need the term to be unfair. And that's what we're going to go on to in just a second. And if that happens, it's void. So let's go on to what unfair means. 3 tests. Firstly, is there a significant imbalance? So if, for example, Telstra and Optus are negotiating with each other about the use of infrastructure in relation to rolling out bits of the NBN, and they use a standard form contract, take it or leave it, same form every time for different areas around the country, there is not a significant imbalance in their relationship. So it is unlikely to meet that test. But if I'm negotiating with Telstra, I use quite loosely there, to upgrade my telephone, and I want to get internet services as well, and they give me their standard contract, there is a significant imbalance between our relationship, because I'm obviously seriously more powerful than they are. I wish. Seeing if anyone was listening. So the claimant needs to establish on the balance of probabilities. On the balance of probabilities that Telstra has more bargaining power than I do. It's also worth noticing here that just because a term isn't transparent doesn't necessarily mean it's an unfair term. And there's nothing to do with good faith here. The question is there an imbalance in the relationship? Is there an imbalance between the benefits going to one party as opposed to the other? So there needs to be that difference between the two. The next part of the test is the term needs to be not reasonably unnecessary to protect the interests of the party who's advantaged. So it might be perfectly reasonable for, in my telephone contract, for example, no, I'll go back to the exam contract. So if, say, your standard form contract with the university says, and I'm sure it does, we've got no obligation to give you a JD at the end of this. We've got an obligation to provide you with subjects, provided that you pass them, and you then go and do the next subject, and when you have enough credit points, you'll get a JD. But if you don't actually meet those criteria, you won't. And that might feel unfair to some of you. You might think, no, I don't actually like doing exams. I would like to do just assignments or some other form of assessment, and it's not fair that that's built into my contract in some way. This analogy is going to get ridiculous very quickly, I can tell, but I'm just trying to get something that means something to you. It might not be transparent why the university picks that particular assessment model. None of those things might be assessed, but it is quite likely that the university would bring some evidence there that it's reasonably necessary for it to maintain its accreditation of the JD program, that people need to meet a particular standard in order to pass subjects and ultimately get to the degree, and that it's appropriate for that standard to be assessed in this way. So it's quite unlikely that that type of term, even though it's not necessarily transparent to you, but in fact wouldn't be an unfair term. Similarly, telephone contract with Telstra. it could say stuff about, I'm sure it does actually, that I might get unlimited calls and texts within Australia, subject to the little asterisk saying reasonable use applies. So I might think that's unfair. I should be able to make as many texts as I like. I should be able to go and do whatever I want to do at any given point in time, and that I've hacked my phone in some way, so I've got minions all over the back blocks of India sending texts to people and running a little small business doing that. Yeah. But actually, it's costing the organisation money to provide that infrastructure. I'm slowing down local bandwidth and doing a whole range of things. It doesn't matter that I don't understand. It doesn't matter that it's not transparent. It's actually reasonably necessary for Telstra to protect itself to provide some limitations in relation to that service. What do we have here? There's a rebuttable presumption that the term's not reasonably necessary. So, if you get past the significant imbalance part, you say, okay, this term is not reasonably necessary, that's where we start. It's then up to, in the example I just gave, Telstra, to bring the arguments that it is. And again, that kind of makes sense, don't you think? Because Telstra, in that example, is in a better position to know why it needs the term than I am to be able to argue why it doesn't. However, the guidance says that an inadequate explanation of complex or onerous terms often suggests that they're not reasonably necessary. Then the last part of the test is that the clause would cause detriment to the consumer if it was relied upon by the company. It needs to actually cause detriment. It's not likely to mislead or deceive. It must actually cause detriment. The detriment itself doesn't have to be financial. It can be any form of detriment. The court may take into account any other matters it thinks relevant. I hate it when we have those provisions. They don't make me feel certain when I'm drafting something at all. But the court can take into account any matters it thinks relevant. It must, however, at the very least, consider the extent to which the term is transparent. So transparent itself is a defined term, and it must consider the term in the context of the contract as a whole. So we read that onerous provision in the context of how the whole contract works, not just by itself. So what does transparency mean? The term of a consumer contract will be transparent if all of the following things are satisfied. So this way, so I can see it needs to be expressed in reasonably plain language. So if you can't understand it, it's not transparent. It needs to be legible. So if it's in a font as small as some of the fonts that we've had on this slide pack tonight, it's probably not transparent. It's presented clearly, and it's readily available to any party affected by the term. So it's not a secret. It's not hidden away. Now, about 10 years ago, it used to be virtually impossible to work out what your phone contracts were, because you would just get one document and then it would refer to 3 or 4 different websites that had all of the other provisions in them. And some of them often wouldn't work, particularly if the terms changed. So this is designed to eradicate that kind of behaviour. Transparency is one factor which the court needs to consider. So this comes from the Office of Fair Trading and Foxtons, referring to a UK similar provisions, but I think this sums it up nicely. Just because a highly skilled lawyer can find or contrive some equivocation in a word does not make the language lacking in plainness or intelligibility. If it looks like a duck, it walks like a duck, sounds like a duck, then it's probably a duck. Plain language, clear language, ordinary course of meaning. Section 25 I mentioned before sets out some examples of what an unfair contract might be. There are 14 of them. Take a look at the section. I think it'll be guidance for you. They include things like terms that permit unilateral changes by one party of the contract. Pretty much everybody's mortgage has got one of those. So when you think about it, if you've borrowed money from the bank, you're waiting every time the RBA changes its rates to see if the bank's going to put your rates up or down. They get to decide. We don't get to decide. We don't negotiate with them. Their rates go up and down. Probably not enough of its own because for the reasons that we spoke about already. Term is transparent and apparent. It's reasonably necessary to protect the interests of the bank. It's now paying more money than it used to for the money it's lending to you. So the rate should go up. If they try and put them up ridiculously, might be a different call. But you can understand that kind of clause. Clauses where a number of other cases we've seen them is in franchise agreements, where the head franchisor gets the ability to change prices or change the equipment that's used or the ingredients that go into the chicken burgers or whatever the franchise relates to. Terms that limit the rights of parties to a consumer contract can be seen as unfair terms. So they might overlap with the statutory guarantees regime that we spoke about earlier. Terms which permit the assignment of a contract to the detriment of another party without that party's consent. So again, franchise is a really good example of that. I've bought the local McDonald's franchise, I'm happily building my business, I want to retire, I want to sell it to you, but McDonald's is just saying no, unreasonably. That could be an unfair, if they've got absolute unfettered discretion, that could be an unfair term, subject to the other things. Sorry, I'm trying to move quickly for you. Okay, let me think. There are a couple of things. Doesn't apply to the constitution of a company. So technically the constitution of a company is the contract between the members of the company and the company itself, about how things will happen, how directors will be appointed, what the name of the company will be, etc. This regime doesn't affect that. So even though when you go in and out of buying shares in a company, you don't get to negotiate the terms of that contract, still doesn't apply. It doesn't apply to contracts relating to ships, marine salvage and towage. We've talked about the ones in section 26 before. What is a standard form contract? Unhelpfully not defined by the legislation. I think this idea of a take it or leave it contract, a pre-printed form, even a tick the box on the website, I think is easy to understand. There's a dictionary definition there. This idea of contracts of adhesion is an old-fashioned language or technical legal language for these kinds of contracts. In other words, they're terms that are put that are not subject to negotiation. Basically, we read them the same way as we read other contracts. Extrinsic evidence is admissible, and yeah, basically there's no particular difference between the way we read these contracts or understand them as for any other kind of contract. Parole evidence rule still applies. The question comes down to those three tests. It's either an unfair term, the report declares it's an unfair term, it's an unfair term, and it reads it in the same way. Sorry, I'm now starting to rush a little bit again. Please just slow me down if I'm going too fast, but I'm realising that we're doubling up on some of the things I said before. These are rebuttable presumptions. They apply the same way. They actually make a great deal of sense. The party who's in the best position to explain themselves has that requirement to rebut the presumption. Firstly, that it's a standard form contract, and secondly, that the provision is not reasonably necessary to protect the interests. Well,
wait, can you describe what you mean by which party?
Well, so if, for example, what I was using before, large telco and me, I think that one of the provisions in their contract is unfair. They say it's reasonably necessary to protect their interests. There's a rebuttable presumption that it's unfair. It's up to them to rebut that presumption. They need to demonstrate that it is reasonably necessary, which makes sense because I don't have the information or the ability to prove why it's not in their interest. And so they have to demonstrate that it is in their interest. So what things does the court take into account? This comes straight from the section. They need to look at whether one of the parties has all or most of the bargaining power. Pretty straightforward. Whether the contract was prepared by one party before any discussion relating to the transaction occurred between the parties. So if there's a negotiation and somebody goes off and creates an agreement, comes back and they sign it, less likely to be a standard form agreement. If people go into a shop, there's a printed form that they can rip off and just ask them to sign, that's more likely to be a standard agreement. Whether another party was, in effect, required either to accept or reject the terms other than the terms referred to, so price, etc., the things that are excluded, in the form in which they were presented, take it or leave it. Whether another party was given an effective opportunity to negotiate. So if you do actually, and it's an effective opportunity to negotiate, presumably not just what colour would you like, but truly on what the terms are, and whether the terms of the contract, other than the terms that are excluded, take into account the specific characteristics of another party or the particular transaction. Or is it a one-size-fits-all? You want this phone, you want this kind of electricity contract, you want this kind of education, that's how it works. But again, court has this broader, the legislation has kept open this idea through the regulations. They can add additional things for the court to think about. So, the Section 250 of the Act provides that the regulator can also take action. So we're now not just talking about this private law between large entity and consumer, but we now have a situation where a regulator can step in, not privy to the contract, and bring action in certain cases as well. So, in relation to a declaration that a term is unfair, the ACCC can go and seek that declaration, but so can an individual party to a contract. To get an injunction to prevent the use of that term going forward, again, individual can do it, or the ACCC can do it. Damages or compensation orders, neither can do it. Now, once you've got a declaration the term is unfair, why can't you get damages? I know we haven't spoken about damages. Can't get them, because once it's unfair, then the term is void, so it doesn't apply. Then, Section 237 and 239, these apply where the term is relied on by large entity after a declaration of unfairness has been made. So the court has said that term's not fair at some point. Then a compensation claim can be made on behalf of a party that actually suffers loss at that point by either the ACCC or somebody who is affected personally. And the ACCC could also bring an order to redress loss or damage to a non-party consumer. Again, you get these kind of outcomes because it's a legislative fine.